We'll start. Now, today, little important topic again, like JJ Act, victimology and victims' rights is also important. But it's so unfortunate that the entire criminal justice system is meant for the victims, but then till recent times. The victim is completely forgotten by the criminal justice system. So this is quite a recent phenomena, we can say. So now legal fraternity is now seriously thinking of compensation, rehabilitation, rights of victims, and that is the reason why we are bringing in the topic called victimology and what are the victims' rights, and then how they can be ensured, rights can be ensured, and what are all the different types of atrocities or massacre or killing or other kinds of violence can be there on victims, and what are different types of victims, who are all the victims, and then can we classify them, or what are the types, and then whether compensation is there for victims only in the major acts, or do we have some measures under some special act, and what is the Indian scenario, and all these are the topics which we are going to cover in this particular session. And let us see the PowerPoint one by one and try to understand what are all the things that are there under the criminology, victimology. Now, we know that the UN Declaration for the first time on justice, it is trying to give victims of crime and victims of abuse of power. So it is going to clearly distinguish between these two terms. That means victims can be there in crimes also, and then whenever the executive, whenever the supervisory level people, when they abuse their power, so in that case also victims are there. So two kinds of victims clearly are distinguished for the first time in UN Declaration on Justice. So they say victims can be of crimes, and victims are also there of abuse of power. Now, the elaborate kind of a definition it gives is victim is any person. It can be individual or collective. That means it can be a single or it can be a group. Have suffered harm. So that means some kind of a harm, including physical or mental injury. Now, in the definition of injury, if we see in IPC also, it says not only bodily injury, and the psychological injury and reputation and all these are included in the injury. So, when we say harm, it is both physical, emotional, mental, and then economic loss in terms of money, and substantial impairment of the fundamental rights. See, the rights are also violated, not only this harm, injury, but then the very fundamental rights which are guaranteed under Constitution of India. So there is some impairment, considerable impairment also is there in the violation of their fundamental rights. And how are they sustaining this? They are sustaining these things via the acts or omissions that are in violation of criminals. So whatever acts and omissions that are declared as crime in the criminal laws, if the victim is going to sustain these physical, mental injury, emotional suffering through the acts of an offender, and which are punishable as per the law, operative within the member states, including those laws prescribing criminal abuse of power. So as we have already said, not only of crime, victims of crime, but victims of power of abuse of power. So these are going to be, UN Declaration of Justice is going to clearly give a definition, and then it says two categories of victims. Now, UN Declaration again recognized, yes.
But the PPT is not moving. It says we are showing the first slide only.
Wait.
Yes, with speed.
Yes, ma'am. Now it's visible.
Okay.
Again, when it comes to the rights of the victims, they are category. The UN Declaration of Justice is recognized, and then it says four components when it comes to the rights of the victims. What are those? Access to justice and fair treatment, that is natural justice. So, what do we mean by access to justice and fair treatment? That is natural justice, as it can be there for any accused persons also. Then restitution, restoring back the original position is restitution. Of course, compensation, whatever injury, whatever harm that she has meted out in the hands of the accused, that particular compensation has to be done by the government. They do it by imposing fine on the accused, and amount will be given. So it can be interim relief or it can be a final amount. So because whatever medical expenditure that is there, that can be projected through application, and that can be given as an interim relief. So compensation is also another thing, and then rehabilitation of the victim is the last. So four categories of rights can be recognized by the UN Declaration of Justice. Now, access to justice and fair treatment. This particular right includes the mechanism of justice to prompt redressal, right to be informed of victim's rights. So, when victim has got rights and when she is unaware of that, and it is the duty of the the state to inform her or him the rights. What are the rights? Whether it is promptness in delivering the justice, prompt redressal of the victim, and then proper assistance, if at all that is there, that has to be given throughout the legal processes, and then right to protection of privacy and safety. So if the identity of the person or the victim is not to be divulged as per the law, it should not be done. When it comes to privacy issues also, that should be, privacy as well as the safety should be protected. So that is what we mean by access to justice and fair treatment. Now restitution, what do we mean? Including return of property or payment for the harm or loss suffered. So if there is any deficiency in the property or payment, whatever harm she has or he has, victim has suffered in the hands of the accused, that has to be restituted, returned back to the victim. So if suppose public officials are their agents are the accused, then they are, as per the restitution is concerned, they will receive the restitution from the state, because public officials represent the state. So when accused are from public services, that is public officials, so the compensation or the restitution has to be done by the state government. So that's what we mean by, it can be property restitution or payment restitution. So that is done by the state in case the offender is a public official or a public officer. Now compensation, we all know that compensation is not fully available from the offender or other sources. So because of the financial position of the offender, if suppose he is not in a position to pay the compensation, then the accused always in such offences like crimes and all will be represented by the state. So in case if he is not financially well and all, not capable of paying the compensation, then at least in violent crimes, where a lot of body injury is taken place. Now there has to be some national fund that has to be created, established, and government will give the victim some compensation through these kind of national funds. Now assistance, what do we mean? In terms of material, in terms of medical, in terms of psychological assistance, social assistance, through governmental, voluntary, community-based means. That means even NGOs can also come forward to help the victims. It can be a medical help, or it can be a psychological counseling kind of a help, or it is a social assistance where some job or some occupation to the victim is what is meant by the assistance. Now, the Criminal Code Amendment, if you see 2008, now you see the meaning of victim given there. Now, it again is a inclusive kind of a definition where it says, who has suffered any loss of injury caused by reason of the act or omission for which the accused person has been charged, and the expression victim includes his, her guardian or legal heir. See, this is a very exhaustive and inclusive type of a definition where you see the victim, if suppose victim dies in the process, now their legal heir, or if she has got a guardian, even they are entitled for this kind of a compensation or whatever, and they are also included as the victims. In the definition of the victim, even guardian, legal heir are also included. The reason is, in case the victim dies, now the trauma or agony, it is not restricted only to the individual, it extends to the extended families also. So that is the reason why now in the definition of the victim, they made it very exhaustive, in that they have included the guardian also and legal heir also. Cutting this. Now, victim means victim of abuse of economic, political, public power. So we have seen in UN Declaration of Justice, we have seen that two categories of victims being identified, that is victims of crime and victims of power of abuse of power. So in that they said economic abuse, political abuse, public power abuse, all kinds of abuses. Now, victims of organized and corporate crime, victims of environmental offences, victims of consumer frauds, victims of development induced crime. That means in the name of development and all urbanization, now a lot of slums will be dismantled, and then they will be thrown out of their dwellings and all. So such type of crimes are also included in the definition of the victim. Now, victims of natural man-made disasters. So a lot of disasters these days in the form of floods, in the form of earthquakes, since it can be both natural and man-made also. So such victims, if they are there, now even those people are included in the definition of the victim. Now, the term victim is lacking descriptive precision. This is what we need to understand. It implies more than the mere existence of an injured party, in that innocence or blamelessness is suggested, as well as moral claim to a compassionate response from others. But not only this injury party, but then they should be seen as somebody who requires her, who deserves a lot of compassionate response from others. Others, we mean not only the public, but the criminal justice system, all the stakeholders of the criminal justice system, namely the police, namely the public prosecutor, namely the defense lawyer, namely the judge himself. So they are to be seen with a compassionate response, and not just as innocence and blamelessness or the injured party. So it goes beyond, the definition goes beyond. Now, types of victimization. How many categories of types of victimization we can understand? Now, it is at three different levels: primary, secondary, tertiary. Now, what do we mean by primary, secondary, and then tertiary victimization? Now, if the harm is directly to the body of the victim, it can be body, economic. We have seen abuse of power and all, or economic, political. So all that, it is directly affecting the victim. Then we call it as a primary victimization. Now, secondary victimization is the one which the society is giving to the victim. That is a lot of negative reactions. Even if somebody gets raped, then people or the social media will say she shouldn't have worn such type of inviting dress, or some restrictions are there on women, they are weak, they are fair sex and all. I mean, society has got its own perception about certain crimes. So the negative reaction that the victim is receiving from the society and all other members of the society, that is secondary victimization. And then it goes to a third level where repeated exposure to the victimization, whether it is court or in the trial and all, there is a lot of victimization. Even after the trial gets over, then when she returns back to the society, again the stigma that is there from the family circle, from the relatives, from the society, a lot of negative responses will be, reactions will be there. So that is tertiary victimization. And when it comes to forms of victimization, we can say 2-3 categories. One is conventional crimes where theft, assault, a lot of bodily injuries, and then the loss of property is also there. And non-conventional, these days, they are little modern crimes wherein human trafficking. Now, human trafficking, most of the time victim is losing its identity, and even if she has some family will not accept the victim, and then they say she has been trafficked, so we don't want to own that lady and all. So this kind of trauma will be there. And environmental crimes, organized crimes are some of the crimes which are non-conventional, non-traditional crimes. And then what is finally the impact of the victimization? What kind of impact will it leave on the victim? Now, it can be physical, psychological, economical, and post-trauma syndrome is there. Then depression is there, social isolation is there, social stigma is there. So these kind of impacts will be there on the victim, and she will also be undergoing this kind of a underlying kind of trauma. Now, some victims are more vulnerable. See, they suffer more compared to others. So the list here is women, children. They are most vulnerable groups. Elderly, the poor, the powerless. These are the ones, victims who are more vulnerable. They become the prey for the abuse of the power shown by the powerful. So these categories of victims are a little more vulnerable compared to others. Now, what is the historical background? If you see, way back in 1940 only, the terminology victimology is there. It is Hans von Henting. He is the one in 1948. He tries to highlight how there will be an interaction between the victim and the offender, and then what is the result of that interaction and all. He tries to dwell upon these kind of areas, and then he is the one who for the first time is trying to highlight these interactions. Now, victimology, as we know, is the study of victims of crime, their experiences, and their treatment by society and the justice system. See, not only the study of victims, their behavior and all, what are the experiences, what is their trauma, and then what negative impact that entire activity has left in their mind. And then if any treatment, suppose medical treatment or psychological treatment, whatever that is there, and apart from that, how the society is viewing them, and then how the criminal justice system is focusing on them, how are they trying to understand these victims. That is what is victimology all about. Now, this word has been coined by Benjamin Mendelssohn in 1947, and then he says the scope extends beyond crime to human rights violations. See, not all human rights violations are crimes, isn't it? But some may be crimes, but then the scope, when you say victimology, it goes beyond crime, and then any human right violations, because after all, by virtue of being a human being, even victims are also, like accused have their own rights, and victims also have their rights, and it is the duty of the state to protect the rights of the human beings. So not only crime, but any other human rights violation also is included in the victimology. Now, victimology is the scientific study of victimization, the relationship between victims and the offenders, then interactions between victims and the criminal justice system. So lot of relationship, lot of interaction, because when it comes in contact with the entire criminal justice system, there are many stakeholders, like police are there, the first interaction with the police, then interaction during the trial, during the defense, or during the cross. So many interactions and relationships will be there. So victimology is talking about these things also. So it is the police, court, correctional officials, all these people, there will be constant interaction by the victim with all these stakeholders. So what are their experiences, good or bad, whatever it is. So victimology is going to talk about this, and it makes a systematic and scientific study of how victims suffer this, suffer the agony in the hands of these people. Now, the connections between victim and other social groups and institutions. So these days, media, social media, businesses and social movements and all. So a lot of connections. Victim is not isolated. She is a part and parcel of the society. So a lot of interactions will be there. A lot of relationships are there. So in all these relationships, she is going to have this kind of a trauma and agony, and this she is silently suffering. So victimology, however, is not restricted but may cater to other forms of human right violation that are not necessarily crime. So we have seen already that. So it goes beyond crime. That means what? Not only the the acts or omissions that are given a sanction under CRPC or criminal laws, but other things, like violation of fundamental rights or human rights. Of course, fundamental rights and all are, they are given under Constitution. They are addressed in Constitution. But then human rights also, human rights commissions are there. So any human rights commission violation also is included in the victimology. So it means not crime, but also it goes beyond. The scope goes beyond. Now, what are the key theories? So like we have theories of criminology, theories of criminal behavior. So also when it comes to victims, what is the theory? There are a lot of theories, and we will not study all the theories, but some key theories in the victimology we can talk about. This is one is victim precipitation, and the other one is repeat victimization. So what do we understand by precipitation? The victims may play a role in their own victimization. So what is their responsibility? Do they also contribute for their own victimization? So that is a theory, a key theory, which says there is also participation, and that gets precipitated, that gets aggravated. If she also plays a role, that gets aggravated. That's what we mean by precipitation. Now, repeat victimization, some victims are more likely to be victimized again and again. So if they are not learning lessons out of the primary victimization, then the same victim may become further vulnerable to further victimization. That is primary, secondary, tertiary, or maybe the fourth order, fifth order. So repeat victimization happens only in case of some victims only. Maybe they are the most vulnerable groups, which we have seen in the previous slide: women, children, adult, then poor people, or the people who are powerless. So they may be the most vulnerable victims, which become repeat victims again. Now, when we talk about victims' right and justice in India, UN Declaration 1985 recognized victim rights. Now, what are the victim rights? We have seen four kinds. We have seen access to justice, that is natural justice, restitution, compensation, rehabilitation. Now, Indian context, we know that historic and all, in the old era, we see Manusmriti is one code, and Hammurabi, a Muslim kind of as many as some 250 odd sections are there. It covers almost entire labor laws, criminal laws, civil laws. A lot of things are discussed, and it is a Babylonian kind of a code which has been written on some rocks and all. This where there also you see the victim compensation is discussed. Now, criminal justice system in India is basically concerned with criminals. We know the very name criminal justice system, we can see that more focus now is there only on the criminals, whether it is their conviction, treatment, reformation. So we talk about only criminal. So we say criminal should be convicted, or whether he can be convicted, or whether it is acquitted, some treatment in case of drug abuse and all. We say we'll give them a chance to reform themselves, and all drug addictions, if they are consumed for personal use and all, we send them to de-addiction centers, and then we don't mind waiving some kind of a punishment for them. And for their own reformation also, we provide a lot of vocational education, and then for their rehabilitation, reintegration, we have so many schemes. But you see, criminal justice system hitherto, it was not focusing at all on the victims. It was more a criminal centric system, we can say. Now, Supreme Court in case of Ramchandra Rao versus State of Karnataka, the first time it says that when it is expressed its concern for the plight of the victims of a crime. So this is the case where for the first time the court and the criminal justice system are thinking about the victims of the crime. So if left without remedy, so any violation of a right, there should be a remedy, isn't it? So any right violation, if there is no remedy for it, people lose faith in the criminal justice system. So that will make people resort to taking revenge by the unlawful means, resulting in further increase in crimes and criminals. So that is the crux of the entire criminal justice system. So whenever rights are violated, courts, if they are not going to restore the right, or if right is violated, if there is no remedy offered by the court, then people lose faith, and people will, the deterrence effect will not be there. So when deterrence is not there, people would like to take revenge. Anyway, I am at a loss, why not I take a revenge? So that way, maybe there is an increase in the crime, and then number of criminals may also be increased. So that's what they said in the case of Ramchandra Rao versus State of Karnataka. Supreme Court reiterated this. Now, recommended various measures for victims' empowerment and rehabilitation. So there are a lot of committees and law commissions which have come forth, and then right from 2003 to 2010, there are a lot of recommendations, a lot of measures that have been suggested, which will empower the victim and which also help the victim in getting rehabilitated. So the first and foremost committee is the Malamuth Committee, 2003. It has brought in lot of reforms in the criminal justice system. So that is one committee. But maybe there also we have seen that victims gets the focus. And second Administrative Reforms Commission is another commission in 2007. In its fifth report, it talks about the public order, where there is also mention of the focus now shifts there for the victim. And of course, law commissions, every law commission, it tries to focus on the victims, and then it is the 226th report where the compensation of the victims has been mentioned, that is in the year 2010. So all these committees, both Administrative Reforms Committee, Malamuth Committee on Criminal Justice Reform, and the law commissions, so they are now trying to focus more on the aspects of the victim, victimization, victims' rights, victims' rehabilitation. So all these things related to the victim is getting focused now. Now, as far as the legal provisions that are there in India, now what are all the legal provisions? What are the provisions in CRPC? What are the sections in CRPCs which talks about the compensation? Now, we see 357. Now, I am only talking about the old section. Somebody interested in the new sections, new law, they can always refer it. There is not much content-wise variation, so you can always have a comparative table and then you can refer. So 357, 59, there is a mention there in the CRPC about the victims' compensation schemes, and we know that amendments have taken place in CRPC, and then the amended version of CRPC 2008 also has given a lot of empowerment to the victims, and then it says you can engage a legal counsel, and whenever the victim feels that whatever the punishment that is given to the accused is a little lesser if she feels, then she can always appeal on that ground for lesser punishment offences. If the punishment is not adequate to the offence that has been committed, then now they are empowered, victims are empowered. There is an amendment that they can also appeal to the higher court in that regard for more punishment for the accused. Now, section 357(1) subclass, if you say the concern itself with the grant of compensation out of the fine. That means, whenever the crime happens, now when trial goes on, and if the offence is proved in the trial, if the presiding officer declares the offender as guilty, then naturally, if, according to the section, it imposes lot of fine and all, and that fine will act as from out of that fine the accused is ordered to pay the compensation to the victim. It can be interim compensation or it can be final compensation. So two types of categories are there again. And if you see subclass 1A in 357, it also empowers criminal courts to indemnify the prosecuting agency against expenses incurred in the prosecution by way of fine imposed on the convict. So convict, lot of fine is imposed, so that includes even the cost of running the trial by the prosecution. So all that will be indemnified by the indemnifier, namely the convict in this case. So this is very well stated in 357 CRPC 1A. So this is empowering the court to indemnify. Now, if you see 1B of the same section, it says that the court to award the compensation for any loss or injury. So, caused by the offence to the victim, but this is subject to the condition that compensation must be recoverable by the victim in a civil court. So, when it is compensation to the individual and all, so that recovery can happen not in the criminal court, but any compensation at the individual level, we may have to again appeal, apply to the civil court, and then there the compensation can be recoverable. So that's what 357 clause 1B says. Now, recoverable, what do we mean? So it is in two ways. What is the first way? That the victim is entitled to sue the offender for damages in civil court and that the offender is liable to pay. So it is a damage. Whenever we talk about civil court and all, we don't call that as a fine, but we rather use the word damage. So we can file a suit there, and then for compensation, it's not called exactly compensation, but we can call as damages. So damages can be recovered through the civil court by a separate suit. Now, the offender had the capacity to pay the compensation. See, offender also should have the capability, financial capability to pay the compensation. Now, 358 in CRPC again, 1973 Act, you see that payment of compensation up to 100 rupees to persons groundlessly arrested. So if somebody erroneously, the police officer, out of over enthusiasm, if without any grounds of arrest, if they are making such arrests, then they said 100 rupees. So those in 1973 it is less amount maybe. Now subsection, if you see 359 subclass again, you see that towards the cost in non-cognizable cases to the complainant. So most of the times in cases, criminal cases, the complainant himself or herself will be the victim most of the time. So for cost towards running the trial of a non-cognizable case, then also the costs are recoverable from the offender. Now 357A, if you see, every state government, there is scheme funds for the purpose of compensation to the victims or his dependents. Now we said in the definition of victim, we also said not only the victim, but the extended families, the guardian or the legal heirs and all. They they are the ones who are going to get the compensation. Now, the states, it is states' responsibility to introduce schemes so that the funds are generated in that, and then through these funds, the victim, or in case the victim dies, her legal heir or his legal heir or her dependents or the extended family, or in case if she or he doesn't have parents, guardian, so they are entitled for the compensation. So they have suffered loss or injury as a result of crime who require rehabilitation. So whenever there is a harm, injury, loss, economic or social, these things have to be rehabilitated. She has to be rehabilitated and she has to be restituted for that. And if the trial court at the conclusion of the trial is satisfied that the compensation awarded under 357 is not adequate for such rehabilitation, or where the case end in acquittal or discharge and the victim has to be rehabilitated, it may make recommendation for compensation. See, trial court, so depending upon what is the quality of the evidence that is there before them, so accordingly it is going to pronounce the judgment. It can be a acquittal or it can be conviction. In such a case, if it is a case of acquittal or if it is a case of discharge, but then victim's point of view, if you try to understand, now she has to be at any cost rehabilitated. So it may make recommendation, though the case may end in acquittal, but nevertheless when it comes to compensation of the victim and her rehabilitation, it is the trial court in the judgment itself, they may recommend for compensation. So there is another situation. What is the other situation? Where the offender is not traced or identified. The case goes on, but then offender is never traced or identified. But the victim is identified, because in all crimes, most of the time victim is identified. Victim is there, but it is the accused who goes at large, or who goes underground and all, or out of sight, or flees away to the other countries and all. So in such cases, what happens to the compensation? So there cannot be trial if there is no offender, no trial, isn't it? If he is not traced, no trial. So victim or his dependents may make an application to the state or the district legal authority for award of compensation. So it is immaterial. We have suffered the loss, we have suffered the harm. So that has to be compensated. So rehabilitation has to be there. Immaterial whether the accused is traced or identified, or whether it has fleeing to the other country, has become underground, it is immaterial. But then loss is loss, that has to be compensated, is another situation. Now, on receipt of such recommendations or the applications, now the legal service authority, after due inquiry, because when it comes to their trial, and they also need to make an independent inquiry about that, and then when they feel, and after inquiry, if they feel that the award is adequate compensation, so they recommend for that. But it is a time bound kind of an inquiry. It should not exceed more than 2 months. So within that time, so depending upon the evidence that they have before the inquiry, and also they make due inquiries about that, and then later on, if they find that it is a fit case, then they award the adequate compensation. But if there is a time stipulation for that, they say whatever inquiry the legal service authority are making, that has to be within 2 months. Now, legal service authority also alleviate the sufferings of the victim, may order for immediate first aid facility. So in case if she suffers some injury, some grave injury and all, so for treatment and all, for first aid and all of the victim, so there should be immediate first aid facility that should be available, and it makes an order. So the legal service authority, after inquiry and all, prima facie, if some first aid has to be arranged, so some medical aid has to be arranged, they are going to recommend for that, and that has to be done free of cost on the certificate of SHO or magistrate. So to that extent, there has to be a certificate by the stationer's officer in case if they are police, and it can also be magistrate. So either of them can give a certificate to that extent that there is a medical urgency or medical treatment is required or immediate first aid is required for this victim. So that has to be done free of cost, and also to that extent there is a certificate. It can be issued either by the SHO or by the magistrate. Any other interim relief as the appropriate authority deems fit. So these are all interim reliefs, because for trial to happen, it may take months together or it may take years together. So in order to avoid that kind of a delay, so there is a provision for interim relief also. So these legal service authorities are vested with the power for immediate recommendation of the compensation. So this is called interim kind of a compensation relief. So to meet out the medical expenditure or to undergo the first aid facility, and they said it is all free of cost. Nobody should charge for these things, and to that extent the SHO himself can give a certificate, or maybe the magistrate himself can also give a certificate to the legal service authority that it is a fit case, and then they need to be given treatment free of cost. Then compensation to the victims in the special laws. As I told you, not only the criminal major acts, but then there are some special acts, special local acts, which also specify the compensation schemes to the victims. So let us see what are those special laws where there is an entitlement for the victim in terms of compensation. Now, under Probation of Offenders Act enacted in 1958, if you see section 5 of that particular act, then you see there is a court direction. So what is the court direction? So court directing the release of an offender under section 3 and or under section 4, a further order directing him to pay such compensation or as the court directs to pay him to the which is reasonable for the loss or injury caused to any person due to the commission of this. So there is a victim, injury is caused by this person, and if the that particular court feels that there is an injury which has been meted out to the victim in the hands of the accused, so under section 3 or 4 of the Probationers of Offender Act, if they are releasing the offender, they said this some compensation which is very reasonable in terms of the offender has to be paid to the victim who suffered the injury in the hands of the offender. So this is one special local act called Probationers of Offenders Act 1958. So section 5 according to that section, and then direction of the court under section 3 and 4. So these are the sections which deal with the compensation whenever the offenders are released. Then if the case is proved that they have caused the injury or the victim has suffered some losses in the hands of the accused, then they say compensation has to be given. Now there is another special local act called the Scheduled Caste and Scheduled Tribe Prevention of Atrocities Act 1989. So where they said monetary relief to the victims of crime, the amount that can be given is some 25,000 to 2 lakhs depending upon the nature of offence and the circumstances of the case. So not in all cases this figure will hold good, but certain categories of crimes and depending upon the circumstance of the case, then they said this is the range, ranging from 25,000 to 2 lakhs is the compensation that has to be, or relief that has to be given to the victims of this particular crime, that is the Scheduled Caste, Scheduled Tribe Prevention of Atrocities Act. Now they said, at what stage this particular compensation has to be given, how much has to be given, the law very clearly stipulates that. Now in case if the charge sheet is submitted by the police, then out of that 25,000 or 2 lakhs, whatever is the entitlement, 25% of it has to be submitted or to be given to the victim at the time of submission of the charge sheet. So remaining 75% now at the time of conviction by the lower court, it is to be given. And I said depending upon the circumstances of the case, that means whether the case is heinous crime or it is a simple crime, petty crime and all, depending on that also the amount of compensation at what stage it has to be given is very clearly given in this particular act. Now in case of heinous crimes as murder and other grievous crimes, Now they said post-mortem, the moment the post-mortem of the victim is done, after the post-mortem, immediately after the post-mortem, 75% of the compensation has to be given to the victim. Now remaining 25% at the time of conviction by the lower court. Now they said lower court, if conviction is done, that is enough. Of course there is appeal and all to the higher court, but need not wait for the appeal time or need not wait for the stage of appeal. But even if the lower court proclaims or pronounces the conviction, even there also remaining 25% of the compensation need to be given. So suppose there is an assault on the women and children. Now dishonor or outraging the modesty, if such or exploitation of her sexual, exploiting her sexually and all, if these types of crimes are there on women, then they said 50% at the time of medical examination, because most of the crimes of recent origin, if you see rape case and a lot of injuries are being inflicted on the victims. So that is the reason there is an immediate need for medical examination of the victim. So they said as an interim relief, 50% almost of the compensation that has to be given initial stage only at the time of examination, medical examination, and of course the remaining 50 can be given even at the end of the trial as a final settlement and all. So if you see this kind of a very minutely, if you try to observe, then depending upon what is the nature of the case, what is the circumstances of the case and what stage it is, and what is the progress of the case and all, depending upon all that, and how serious is the crime or the nature of the crime, depending upon all that, then in case of women, crime against women, there is some percentage. In case if it is a very serious crime like murder, the pattern is something different, and in case of some other type of crime, it is something different. So it's not uniform in all cases is what we need to observe. And if you see 70% of the cases, the accused are not punished by court due to procedural lapses. This is but natural. I mean, it is a very common phenomena that we observe day in and day out. Now, most of the crimes we see that, because lot of loopholes are there in any enactment. So it is the defense lawyer who studies the law very effectively, and he is the one who is going to take out all the loopholes and then use it for the best of his abilities and then ensures that his client goes scot-free, or at least lesser punishment is given to him. Now this is been a judgment is delivered to this extent in a case of Nagpur bench of Bombay High Court in CBA versus Sakru Maghu Benjavar. So and others. This is a case where they said there are the accused are going to be scot-free, or they are not being punished because there are a lot of procedural lapse, loopholes, and it commutes. So in this particular case, what you see is where there is a death penalty by the trial court. Now that is being reduced to life imprisonment, and they are going to they are not accepting the fact that it's not a case of SCST, but then this killing is not caste atrocity, so we don't agree for that. They refuse to accept this particular thing. So whatever killing has happened, it's not an account of somebody being it's a case of SCST case, but rather it's a normal killing. That's what they try to dilute the case in to tell you, in other words. So this is a typical case where taking out the loopholes from the case, the accused gets a lesser punishment, where otherwise it's a death penalty. The court has reduced it to the life imprisonment. And not only that, they also said that it is a normal killing, it's a normal murder, it's not an account of the caste, or it's not a caste atrocity. So they have completely diluted the case. Now, another special local act which we can talk about is the Domestic Violence Act 2005. Now, the Act provides more effective protection of rights of women guaranteed under the Constitution. We know that Constitution is very favorable for weak and vulnerable groups, and women, of course, are the most subdued group and all, and Constitution has given a lot of guarantees for women, and then who are victims of violence of any kind occurring within the family. So when we talk of domestic, it implies that the silent sufferer is the wife or the sister or any female member of the family, and then it is a family setting, and then most of the domestic violence crimes are never reported, and even if they are reported, they have been afterwards also they will be put to a lot of tension, because she has to after all live within that family only, and there will be taunting always by the family members. So section 20 to 24 are very relevant as far as the protection of the victim is concerned, and compensatory justice is the essence of Domestic Violence Act. Now the trial court may, on an application being made by the aggrieved person, most of the time it is the lady of the family, and they will pass an order. There are different orders, home staying in the same home order and all. I mean, there are a lot of orders that the court can give under this Domestic Violence Act, and the respondent to pay compensation damages for the injuries. Now, including mental torture. So when we say injury, in the very definition, we know that it is not only the physical injury, the mental agony, mental injury, and then reputation and all is included in the definition of the injury. Now, emotional distress caused by the acts and domestic violence committed by the respondent. So for all that, there is an order. The trial court can give a lot of orders, where whatever damage, it can be for the physical injury, or it can be for the mental trauma, or it can be for emotional distress, whatever the victim has undergone in the hands of the accused or the respondent, he is liable for compensation. And then the trial court will always, on an application, of course the aggrieved party has to give an application, and the application will be entertained by the trial court, and then to that extent, towards that direction, the court is going to give an order of compensation, and then the victim is entitled for that kind of a compensation. And of course, the respondent is the one who is going to pay the compensation. Now, there are some bills which have not become acts. So we'll also discuss those bills which are pending for approval to become an act. And one such kind of a bill is, custodial crimes. So these days we hear day in and day out a lot of custodial crimes, police torture, police violation of human rights and all. I mean, that's happening in the custody of the police. So these custodial crimes, prevention, protection and compensation bill is also there pending. Now the proposed bill aims to prevention, protection against custodial crimes. So not only it talks about prevention and protection, and it also talks about the compensation to the victims of the custodial offences. Now, custodial offence, as we know, it is not only the violence or death of the person. In case of death of the victim, of course, as per the definition of the victim, it also extends to the family, extended family, the guardian in case if the parents are not there for the victims and all, that compensation has to be given to the victim. Now, there is another bill pending which is called Communal Violence Bill. Now, whenever there is communal violence that happens, earlier Hyderabad, it used to be more rampant. These days, we don't hear this so much. But then whenever communal violences are there, now this particular law has a provision for prevention and control of communal violence and speedy investigation in such cases of violence and trial. And of course, victims will be there, and then it also has a provision to rehabilitate the victims. And there is a National Advisory Council for that, Government of India, and a core group of human rights activists are also there, and they are the ones who are going to examine the case about the efficacy, effectiveness of the bill in the context of the rights-based approach to the victims of the communal violence. So human rights activists are also seriously examining this, and the bill is in the name of Communal Violence Bill. So this is another kind of a bill. Now there is yet another bill which is pending, 2010. This talks about the Prevention of Torture Bill. Now the critic is that definition of torture and weak redressal mechanisms lack of compensatory provisions. So whenever there is a torture, like any other violation, and even that has to be addressed. So there is hitherto a weak redressal mechanism. Now this particular bill talks about strengthening such a redressal procedures, so that even in case of a victim who has undergone torture, they also need to be compensated properly. Survivors of the torture and their families, so they need to be compensated. Now, there are again lot of schemes the government promotes, which are some of them at least are worth mentioning. So they're already in place. And what are these schemes? Schemes meant for relief, rehabilitation of the victims of rape, and then extremist left-way extremist violence. There are compensation schemes for that, and central schemes are there for the assistance of the victims of terrorist and communal violence. And when we talk of rehabilitation, there are packages in the form of relief to the victims of riots and all. And there is Ujjwala scheme again for the prevention of trafficking and rescue, because most of the time, as I've told you already, human trafficking is a very serious kind of a organized crime, in that the victims most of the times lose their identity. They lose their identity, and even the family members most of the time, they disown the victim. So for that reason, there has to be some institutionalized schemes which will help the trafficked lady, because she is in the identity crisis. Now, for their rescue, for their rehabilitation, again reintegration of the victims into the society, or they should not again be in the hands of the commercial sexual exploiters. For that also we need to have a lot of measures and lot of schemes for the trafficked women or trafficked victims. These days, women are then, we include in the list of victim not only the not only the females but also males. Now, Domestic Working Women's Forum versus Union of India. This is a Supreme Court case where domestic working, that is the NCW, to evolve a scheme. So the scheme is to wipe out the tears of the unfortunate victims of rape. A rape victim will be entitled to get a compensation, they said almost 2 lakhs, provided she testifies in court of law against the accused. So she has to testify against the accused. So she is entitled for a compensation of 2 lakhs. And Constitution of Criminal Injuries and Compensation Board at district, state level, national level, a 3-tier kind of a board, so which will talk about the compensation of the criminal injuries suffered by the victim. And the board shall take into account the pain, suffering, to what extent the victim has suffered this agony, pain, a shock, or loss of earning, or maybe some other expenses for the childbirth, or maybe result of a rape. So if the pregnancy is an account of rape and all, the pregnancy charges, the expenses of the childbirth and all will be borne. So the board also will look into these kind of sufferings of the victim. And there is a provision which talks about the budgetary requirements of the scheme, which would be transferred to the state as grants in aid. So states do get grants in aid from the central funds, and also there is a special budgetary provision that has been made to meet the expenditure on account of all these schemes which we have discussed so far. Now, district level committees are also there, headed by district magistrate, to consider the claims. So whatever claims that are there made by the victims, then they are setting up the district level committees where the head is the district magistrate himself. Now, the schemes are there to compensate the victims of violence by left-wing extremists. The Ministry of Home Affairs, security-related expenditure to Naxal-affected areas, so that's been created, and then ex gratia to the victims of crime in the hands of left-wing Naxalism is also there. What is the scale of ex gratia that can be paid to the victims? So it is given, and to the family of civilians killed, 100% with maximum ceiling of 1 lakh, and to the family of a security of the personnel killed, 100% with the maximum ceiling of this. So what is the amount, what is the scale of ex gratia when somebody is a victim of violence by the left wing extremism? So that is being given. So what should be the scale? So 1 lakh is the maximum seal, 100%, and 3 lakhs to the family is what is given. Now, central schemes are also there, as I said, central schemes for the assistance of victims of terrorism and communal violence. The Government of India, again, Ministry of Home Affairs, has given a lot of notifications to the assistance of the victims of terrorist and communal act, and which is being implemented, which comes into effect from April 2008. It is being given now. Now, I said, 3 lakhs will be given to the family, irrespective of the number of deaths that happen in the family of a particular incident, and the principal amount would be deposited in a nationalized bank for a lock-in period of 3 years, and then whatever interest that is getting accumulated in the above sum will be credited to the beneficiaries, and a district level committee will be appointed under the chairmanship of district magistrate, who will assist in identifying the beneficiaries, and while examining the eligibility claims, the district committee will take into account the FIR, the post-mortem certificates, for determining the rightful beneficiary claimants. So these are some of the measures. If you have to summarize the terrorist victim scheme, these are some of the schemes that the government has introduced. Now, the MHA, after examining the case, as I said, issue the check in the name of the beneficiary, and this will be sent to the district magistrate, DM, for disbursement. And in case of employment, if given to any family members of a victim of terrorist violence, the family will not be entitled to the assistance, because all the benefits cannot be given to one family. So in case if the government has promised some employment, so such families will be desisted. They will not be given any kind of compensation, because employment is already given to them. So those permanently incapacitated, the member of the victim killed or permanently incapacitated on account of terrorist activity, will be given a health card by the district health society funded by National Rural Health Mission, and they will be given that kind of a card, and they can avail the free medical treatment for such victims or their families. Now, rehabilitation packages are as a measure of relief are given to the victims of rioting in 1884. Now, in that scheme, 3.5 lakh each for the families, nearly 3,500 people who died in that riot got benefited, and 2 lakh each for 22,000 odd sick families were benefited, and 10 times more compensation for people who lost their homes and business has been given. So these are some rehabilitation packages which were given in 1984 riots, as per the Nanavati Commission report, 1985 anti-Sikh writings. And Ujjwala scheme, we have already said, somebody who have suffered this sexual exploitation, commercial and sexual exploitation. Ujjwala is the name of the scheme that is given, a very comprehensive scheme for the prevention and trafficking of women, and then rescue, rehabilitation of women and child victims of trafficking for commercial sexual exploitation. And 2007, the Ministry of Women and Child Development, they have given these schemes. And for women and child victims who have been trafficked for commercial sexual exploitation, as well as for those women and children who are vulnerable to becoming victims of this crime. So all these people, vulnerable groups, especially when they become victims of commercial sexual exploitation, or for that matter trafficking, then Ujjwala scheme is the best scheme that they will be entitled for this, and under this scheme for the compensation. Now, so the main beneficiaries, if you see the target group, who are all the main beneficiaries? The slum dwellers, and then the children of sexual workers, refugees, homeless victims, and natural disasters. These are all the target groups who are the main beneficiaries. Now, non-governmental organization can also contribute towards this mission. Direct aid and benefit to the victims of trafficking immediate relief can be there, so in the form of food, shelter, trauma care and counseling. So later on, skill development, skill training or capacity building or job placement. So later on, immediate and later on, later after effect also there are schemes, and they are the main beneficiaries. So prevention, rescue, rehabilitation, reintegration, repatriation, these are the 5 components that are involved as far as the main beneficiaries are concerned. Now the Supreme Court in Gujarat versus Honorable High Court of Gujarat has given, State of Gujarat has directed that the prisoners should be paid equitable wages for the work done by them. So whatever vocational courses they are doing, and out of that, if they are eking out livelihood out of that, they said equitable wages need to be paid for these prisoners. And every prisoner must be paid wages for the work done by them, and the state concerned make law for setting a part of a portion of the wages earned by the prisoners to be paid as compensation to deserving victims of the offence. So whatever earning that they are making in the form of wages, so that can be paid as a compensation. So this is a significant development in providing restorative justice as far as the victims of a crime are concerned. Now, Government of India, Minister of Home Affairs, MHA, has issued a lot of advisories, and out of them 2 are very important advisories. So they talk about the victimization prevention of vulnerable sections of the society, such as women and children, and of course the marginalized groups of the society. And crime against women, children, desks need to be set up in each police station. In case of crime against children, should be thoroughly investigated, and charge sheet should be filed against the persons within 3 months from the date of occurrence of the crime, and there should not be any compromise with regard to the quality of investigation. So these are some of the measures that the government has taken up, and steps to be taken up not only to tackle such crimes, but other trauma ensuing the crime all need to be addressed. Now counseling is one such thing to the victims, and not only to the victims, because the trauma is for the entire family, so they need to be given lot of counseling and towards empaneling. So there should be a body of professionals, and there should be constant empaneling of these professionals who are acting as a counselors, and possibility of associating NGOs, because government always believes in the private participation of the civilians also. So NGOs are also coming forward in the area of combating the crime against children and other vulnerable groups of the society. So developing a community monitoring system to check the case of violence, abuse and exploitation against children, and take necessary steps to curb these kind of crimes. Now there are lot of such things which are there, the rest of the things are there, and they are very simple to understand, and you can read and understand this. And FIR is registered, a signed copy, and if this happens, FIR, a signed copy free of cost should be given to the complaint, and this is all free. No earlier the FIR, to give a copy of it, we need to go to the police station and then sit there hours together, and then you receive a lot of excuses from the writer saying the sir is on bandobast, sir is not available, sir is otherwise busy, we cannot give me FIR now, you come some other time, and all these kind of harassment will be there in the hands of the writer and others. But then you can always have a remedy in the law. So FIR, whenever it is registered, a signed copy always has to be given, and it is entitlement of the complainant that they receive a copy without any cost, free of cost. Now, what are the judicial measures, rights to victims, compensation, Supreme Court, High Court? So under Article 226, 32, violation of human rights, fundamental rights for Supreme Court and High Court. Rights of compensation to the victim for violation of human rights, and the landmark judgment we all know, Redel Shah versus State of Bihar. Now this is a case in which petitioner was illegally detained in Ranchi jail for almost 14 years 14 years is almost a very considerable time in the life of any person. So even after his acquittal, so it is an acquittal, but then nevertheless his crucial period of life, almost 14 years he has spent in jail. So they said compensation has to be given. Now Supreme Court directs towards not only release of the petitioner, but then a total amount of 35,000 those days is quite a big amount by way of compensation. This is one first landmark case in which Rudal Shah case versus state of Bihar. So not only he is acquitted, but then it is not sufficient because crucial period of time he has spent almost in jail. So to that extent the compensation has to be given. So almost some 35,000 rupees is awarded as a total towards the compensation. Now interim relief fund also, as I said, the Human Rights Commission gives under section 18 of Prevention of Human Rights Abuses Act. Now it recommended to the government any or all of the following measures. What are the measures? So the measures are that registration of criminal case against guilty persons is number one, and pay immediate compensation to the victim and family, and take disciplinary action against the guilty persons, and then stop a particular act if it is violation of human rights, and then properly perform its duty and protect those whose human rights are being violated, and then take preventive measures so that human rights violations do not take place in the future. So these are some of the recommendations of the Human Rights Commission, and they have recommended to the government. Now, rights to victims rehabilitation, a landmark case, custodial torture of Rakesh Kumar versus Uttar Pradesh, NHRC case. Now, in that case, NHRC asked the UP government to constitute a medical board to assess the extent of physical disability suffered by this victim due to torture by UP police. So, whenever there is a custodial torture by the police, and then NHRC is always the National Human Rights Commission. So they said, please refer this case to medical board and let the medical board assess what is the damage, the extent of damage and disability suffered by this victim. So accordingly, based on the medical board's report, you please award the compensation. Then the commission thus directed the UP government to pay to this victim, namely the Rakesh in this case, 10 lakhs by way of immediate interim relief. So this is, they have recommended the interim relief in this case because there is a disability that is being suffered by the victim, because police have used their third degree to such an extent that the victim has suffered a lot of disability. So they said as an initial measure, give him the interim relief, not less than 10 lakhs. Then the government was also directed to arrange for the complete medical treatment, not only give the interim relief, the entire medical treatment of that victim, let the government bear that. So they have also given this kind of a direction. Now the expense of treatment plus travel expenses of the victim along with one attendant. So this is, see, to such an NHRC is so powerful and all, they can recommend to the government. And then they said not only the expenses of treatment, in addition one attendant, if she is the victim is accompanied by an attendant, give her the travel expenses also, and that has to be borne by the government, because police after all they represent the state government. So whatever in actions or violations on the part of the police is as good as the violation by the government. So let the government pay for the compensation. Now another civil society, what is the role? Now civil society organizations, they also play a crucial role in victim rehabilitation support and reporting victimization, then investigation properly, fact finding of the victimization, advocacy for rights, and documentation and research leading to policy formulation, and then campaigns, and then networking of showing solidarity for victims and rehabilitating and again reintegrating the victim into the society are some of the measures. Now empowerment, what are the empowerment measures of victim? If you see, both legislative, judicial, administrative measures. In terms of compensation, when you talk of domestic violence, and Ujjwala scheme we have talked about, in that 25%, 75%, 50%. So like that they have fixed the compensation, at what stage it has to be given, at what kind of crimes it has to be given, and all. They have already talked about this. And in conclusion, what we can say is, recognizing and addressing the needs of the victim is the order of the day, and there is always a step forward. So when you empower the victims and improve the legal framework, ensuring the justice, you have done a lot of justice to the victim. So that's all for today from my side in this session. And probably tomorrow, being a holiday, there will not be any class for tomorrow. So again, we'll meet in the same platform day after tomorrow. So we'll leave the meeting for tomorrow. తీసేయకండి, అదే లేదు ఇప్పటికీ.
మంచిగా తీసుకో. ఇదిగో నా దగ్గర ఓల్డ్లో ఉన్నాయి.
ఇంకొక ఆఫ్ చేయి. లేదు మీటింగ్ అంటే అప్పుడు ఆఫ్ చేయాలి. అమ్మ చెప్పండి, మీరేమిటి ఏమన్నారు?
నేను మెసేజ్లు పెట్టా అప్పుడు ఇమీడియట్ చెప్తున్నప్పుడే మెసేజ్లు పెట్టేసిన. అట్లా కాదు
ఇది పెట్టాలా వద్దా? ఇది పెట్టద్దా?
పెట్టుకోవచ్చు, ఏమన్నా కాదు కొంచెం ఆఫీస్ వల్ల సార్ కాదు ఉంచకుండా
ఉంచకుండా అంటే అట్లా లేచినప్పుడు అడగలేదు.